Every single month, millions of retired Americans go through the same routine. They open their bank statement, they look at what arrived from Social Security, and they figure out whether they can cover their bills, their prescriptions, and their groceries all at once. For many of them, that calculation does not always work out. And that is not because they did not plan. That is not because they did not work hard enough. That is because the system they paid into for decades has not always delivered what it promised. Today, we are covering something that changes that equation in a very real and very legal way, something that took place at the highest judicial level in this country and that affects every retired person, regardless of which state they live in, regardless of which party they vote for, and regardless of how long ago they filed their last benefit claim. Watch this from beginning to end because every section of what follows builds on the last, and the full picture is what matters here. 9 justices, not one dissenting voice, and the financial security of every retired person across all 50 states now looks different because of what was just decided inside the most powerful court in the nation. This is not about politics. This is not about one side winning and the other side losing. This is about a unanimous decision, which means the justices who are considered the most conservative and the justices who are considered the most progressive looked at the same case, examined the same evidence, read the same law, and landed in exactly the same place. That does not happen often. In fact, on a court that has been as deeply divided as this one has been for the better part of several decades, a ruling where all 9 justices agree completely is not just rare. It is the kind of thing that gets studied in law schools for generations. What this court just decided has a direct line to the retirement security of millions of Americans who gave their working years to jobs, paid into Social Security with every paycheck, and were told that the program would be there when they needed it. This ruling changes the legal structure around how those benefits are protected. It changes how benefit reductions, claim denials, and payment delays can be challenged. And it changes what power you actually have as a retiree when the agency responsible for your benefits makes a decision that you believe is wrong. Before this decision came down, something was happening inside federal agencies that most retired Americans had no idea about. Decisions about Social Security benefits were being made administratively, and the ability for ordinary retirees to challenge those decisions in any meaningful way was extremely limited. The process was layered with bureaucracy. Appeals dragged on for months or years. And the results were frequently unfavorable to the retiree, not because the law was against them, but because the agency interpreting the law held nearly all the power in the room. People who had been wrongfully denied benefits or whose monthly payments had been quietly reduced without adequate explanation found themselves navigating a system that seemed built to discourage them from fighting back. And for retirees living on fixed incomes where every single dollar matters, the cost of fighting a federal agency, financially and emotionally, was simply too high for most people to bear. So they walked away. They accepted less than they were owed, and the system continued operating exactly as it had been. That was the environment before one retiree decided not to walk away. This was a man who had worked his entire adult life, contributed to Social Security through every year of his career, and arrived at retirement expecting to collect the benefits he had spent decades earning. What he received instead was a series of administrative decisions that quietly reduced what he was owed. He did not accept it. He went through every internal appeal available to him. He submitted every required document. He followed every procedural rule to the letter. And at each step, the agency relied on its own reading of its own regulations to justify its own decisions against him. There was no independent voice in that process. The agency was the player, the referee, and the scorekeeper all at once. He brought his case to federal court. It moved upward through the judicial system until it landed before the Supreme Court of the United States. And when those 9 justices looked at what had happened to this man, when they examined the broader pattern of how federal agencies had been exercising nearly unlimited authority to define the laws that controlled retirement benefits, they did not break along the familiar ideological fault lines. They came together completely 9-0. The core of what the Supreme Court decided rests on a principle that is straightforward but carries enormous weight. A federal agency does not have the right to be the final word on what the law means when that law governs the benefits that citizens have legally earned. For several decades, a legal framework known as the Chevron Doctrine had given agencies exactly that kind of authority. Whenever a law related to Social Security contained language that was ambiguous or open to interpretation, the agency administering that program was permitted to define what that language meant. Courts were then told to accept the agency's interpretation, provided it was not completely unreasonable. Not whether it was correct, not whether it served the retiree fairly, just whether it fell somewhere within the range of reasonable conclusions the agency could draw. Consider what that actually meant for a retired person trying to fight a benefits decision. Imagine signing a contract with someone who is legally obligated to pay you a set amount every month for the rest of your life. Now imagine that every time a disagreement arises about what that contract requires, the other party is allowed to sit in the judge's chair. They decide what the confusing parts mean. They resolve every close call in their own favor. And the actual court is told to respect those conclusions as long as they seem plausible. That was the operating reality for American retirees challenging Social Security decisions in federal court. The agency had the law, the interpretive authority, and the institutional weight all on its side. The retiree had almost nothing. The Supreme Court reviewed that structure and determined it was constitutionally unacceptable. The responsibility of reading and interpreting the law belongs to courts. It has always belonged to courts. That principle is embedded in the foundation of American law and goes back further than any modern regulatory agency. When a retiree now goes to federal court to challenge a Social Security decision that reduced their payment, denied their claim, or delayed what they were owed, the judge handling that case must conduct a genuine and independent review of what the law actually says. The judge cannot simply rubber stamp whatever the agency concluded. The judge must read the statute, apply it honestly, and determine whether the agency got it right or got it wrong. That is the change. That is the weight of a unanimous Supreme Court ruling landing inside the retirement system that tens of millions of Americans depend on every month. If you are already collecting Social Security, if retirement is somewhere in your next 10 years, or if someone in your household relies on those monthly payments to cover basic living expenses, this is not a distant legal story. This is a structural change to the system that determines how much money arrives in your account and what recourse you have when that amount is not what it should be. One thing that almost no coverage of this ruling is discussing is the fact that its impact varies depending on where you live. Social Security is a federal program, but its administration touches state-level processes in certain benefit categories, and the way agencies have historically interpreted benefit rules has not been uniform across the country. Some states have used administrative interpretation more aggressively than others to restrict certain types of benefits. Some states currently have substantial backlogs of denied or disputed claims sitting in the appeals pipeline, claims that were evaluated under the old framework where the agency's word was essentially final. Those cases are now being reconsidered through a completely different legal standard. For retirees in those states, the number of people who may now have real and legitimate grounds to reopen past decisions and demand a genuine legal review of whether the agency applied the law correctly is not small. This is the opening of a pathway that has been closed for a very long time. Not a guarantee of a particular outcome, but a genuine opportunity to have an independent legal authority actually look at what happened and make an honest determination. Now let us go through the specific benefit categories where this ruling carries the most immediate practical weight. The first is Social Security Disability Insurance, or SSDI. Initial applications for SSDI have faced very high denial rates for years, and a substantial portion of those denials trace back to how the agency interprets the medical and functional standards written into federal law. Courts were previously expected to accept those interpretations with minimal scrutiny. That expectation is gone. If your SSDI application was denied and the basis for that denial rested on the agency's reading of eligibility criteria rather than a clear and obvious provision of the law, you now have considerably stronger footing to challenge that decision before a federal judge. The second area is survivor benefits. A surviving spouse has the right under federal law to collect Social Security benefits tied to the deceased partner's work record. But the rules surrounding those benefits, particularly in situations involving the length of a marriage, the timing of when a claim is filed, or how survivor benefits interact with other income sources, have long been subject to agency interpretation. Those interpretations carried enormous weight in court under the previous framework. They no longer carry that same automatic protection. A court examining a survivor benefit dispute can now independently evaluate whether the agency applied the law the way the law was actually written. The third area involves the rules around retirement benefit timing, early claiming reductions, and situations where a retiree spent part of their career in a job not covered by Social Security. These are areas where the technical complexity of the law created many opportunities for agency interpretation. Some of those interpretations have quietly reduced benefit amounts by thousands of dollars per year for affected retirees. With the old deference standard eliminated, legal challenges to those interpretations now rest on a fundamentally more level playing field. What most analysis of this ruling is failing to capture is the effect it will have on how agencies make decisions going forward, not just how courts review decisions that were already made. Administrative law judges and senior officials inside the Social Security Administration are now operating with the clear knowledge that their interpretations of the law will face real judicial scrutiny if challenged. That knowledge changes the internal calculus of how decisions get made. When the possibility of independent review is genuine rather than theoretical, the incentive to interpret ambiguous rules in favor of administrative convenience rather than the retiree weakens significantly. The accountability created by this ruling is not only about correcting past mistakes, it is about improving the quality and fairness of the decisions being made right now, today, for retirees across the country. For someone who is in their mid-50s and looking ahead to retirement in the next decade, the Social Security Administration that will process their claims, calculate their benefit amounts, and respond to any disputes they raise is an agency that now operates under a different kind of oversight than it did before. That is a meaningful improvement to the environment into which those future retirees will be entering. One more misconception needs to be addressed directly because it tends to spread quickly whenever a court limits the authority of a federal agency. Some people hear this kind of ruling and immediately worry that it means benefits are going to be cut, or that the program is somehow being weakened. That is not what happened here. This ruling does not reduce a single dollar of Social Security benefits. It does not create any new authority for Congress or any administration to shrink the program. It does not expose the program to new vulnerabilities. What it does is give individual retirees a stronger legal position when they need to challenge a decision they believe is incorrect. It moves interpretive authority from the agency to an independent judiciary. For retirees, that is a gain, not a loss. For those wondering whether a past denial or reduction can now be revisited, the answer depends on the procedural status of your specific case and the timeframes involved. Federal deadlines for challenging agency decisions are real and they remain in place. But for cases that are currently in the appeals process and for new challenges filed from this point forward, the legal standard has genuinely changed. Senior Support USA and attorneys who specialize in Social Security law are already examining the implications for clients whose cases were decided under the now eliminated deference standard, and there are legal avenues being explored that did not carry meaningful weight before this ruling. The legal community working in this space is not treating this as a routine development. For advocates and attorneys who have spent years representing retirees in benefit disputes, this ruling removes a structural barrier that made their job significantly harder and their clients' outcomes significantly worse. The tools available to challenge an improper agency decision are now more effective than they have been in decades. And for the retirees those advocates serve, that is a concrete and tangible change. And this is where the human side of this story deserves a moment of honest attention. Behind every denied claim, behind every reduced monthly payment, behind every appeal that dragged on for 2 years before going nowhere, there is a real person. There is a retired teacher who taught for 35 years and cannot understand why her benefit amount came back lower than her statement projected. There is a construction worker who spent his career doing physical labor and now, dealing with a serious medical condition, cannot get his disability claim approved despite multiple attempts. There is a widow in her 70s who was told her survivor benefit would be calculated a certain way and has been living on that reduced amount for years without ever knowing she may have had legal grounds to dispute it. These are not edge cases. These are the kinds of situations that Social Security attorneys encounter every single week across every state in the country. And every one of those situations now exists in a legal environment that is more favorable to the person making the claim than it has been in a very long time. The ruling did not change their individual circumstances overnight, but it changed the legal landscape in which their circumstances can now be reviewed, challenged, and potentially corrected. This ruling also carries a broader message about the relationship between citizens and the administrative state. For a long time, the assumption embedded in federal regulatory culture was that agencies, by virtue of their expertise and their proximity to the programs they run, should be trusted to define the rules that govern those programs with minimal interference from courts. The Supreme Court just said unanimously that when the program in question controls the retirement income of ordinary Americans who earned those benefits through a lifetime of work, that level of deference is not appropriate. Courts have a constitutional role. They will now play it fully, 9-0. On a court known for division, every single justice looked at whether federal agencies should hold unchecked interpretive power over the retirement benefits of American citizens and reached the same conclusion. No, the message delivered to every agency, every administrative official, and every decision maker operating inside the Social Security system is clear. The courts are no longer watching from a distance. They are fully engaged, and the law will mean what it actually says. If you have spent your working life paying into Social Security, if your retirement depends on receiving what was promised, if someone in your family is navigating a benefit dispute right now or living on a monthly payment that is lower than it should be, what happened in that courtroom matters to you in a direct and immediate way. This is the most consequential legal shift in retirement security in a very long time. If this gave you something valuable, share it with someone who needs to hear it. A parent, a sibling, a friend who is a few years from retirement and has never heard of the Chevron Doctrine, but whose financial future just got a little more protected because of what 9 justices agreed on. Leave a comment telling us your state and whether you or anyone you know has dealt with a Social Security dispute. Subscribe and turn on notifications because the state-by-state breakdown of how this ruling applies in practice is already in production, and it is the kind of specific, actionable information that this channel exists to deliver. 9 justices, 0 disagreement, 50 states, 1 retirement system that just became more accountable to the people it was always supposed to serve. That is what happened, and now you know exactly what it means.